Thank you, Mr. Justice Witt. Caribbean Court of Justice, Appellate Jurisdiction, an appeal from the Court of Appeal of Belize, monitoring hearing in CCJ Appeal BZCV number 2 of 2014 between the Maya Leaders Alliance and 23 other villages and the Attorney General of Belize. The members of this morning's panel are Mr. Justice Witt, presiding judge.
Good morning, Counsel.
Mr. Justice Anderson.
Good morning, Counsel.
Madam Justice Rajnatli.
Good morning, everyone.
May we have the appearances, please? Thank you.
May it please you, Your Honors. Leslie Mendes, together with Alistair Jenkins, appearing on behalf of the appellants.
And Andrew Marshallek, together with Samantha Matut for the respondent.
Yes, thank you very much. I see also Professor Solorio and Dr. Figueroa are present. So thank you for your presence. We will come back to you soon enough. It is clear that, of course, the court read all the papers. The file is growing, but we are still keeping up. I think what we would want is this, that you each will have an opening speech of 5 minutes, which will force you to really go to the essential points of your position. And then, of course, we take it from there and go through a series of issues that are important, at least in the view of the court. So, Ms. Mendes, I would like to pass word to you. 5 minutes to give your opening speech.
Grateful, Your Honors. Well, as Your Honor would have indicated, we have filed reports in this matter to update the court. And I'm sure that at least from our position, Your Honors can deduce that we consider the state of this process to be rather in a state of chaos at the moment. And from our perspective, we had predicted this, Your Honors, ever since we noticed that when there was a change of administration, we noticed that there was this increased interest in the internal affairs of the Maya people. We brought this repeatedly to the attention of the courts because we did consider that this was threatening the sustainability and the stability of this process. We saw that the commissioner and the ministry was exhibiting an insistence on choosing who the legitimate representatives of the Maya people are. Once again, for us and the experts agree that it is not for the government to act as an arbiter of legitimacy among the communities as to who their representatives are. It is not for the government to decide who the winners and losers are among the communities. And we say that this is in fact what is happening. We have highlighted in our response one of what we think is a glaring deficiency in the opinion provided by Dr. Figueroa, because we say that even though she does accept the position that the government has no place in choosing the representatives, Your Honors, the impact of her position is one that leaves the door wide open for the government to, in fact, do just that. In her opinion, she assumes the legitimacy of all of these representatives institutions, of all of these other organizations. We say that we have been here for 7 years now. For 7 years, the respondents have been well aware as who it is speaking with. And despite the fact that specific parties entered into this consent order, despite the fact that it is only one institution that is made up of the collective of the duly elected leader among the communities, this election is rooted also in their customary process, Your Honors. We are saying that what we are seeing now, 7 years later, is an attempt to completely unsettle the representation of the Maya people and by extension, unsettle this particular process and upend this particular process. Your Honors, in that vein then, we do highlight again that from our perspective, Dr. Figueroa had displayed very little knowledge about the TEA, and it would seem that all of the knowledge that she obtained would have been provided by the government, which again, we showed very clearly has been displaying quite some animus towards the TEA, considering now an corruption of the alcalde system. There is no dispute about the legitimacy of the alcaldes, Your Honors. There is none. The only thing and the only effect, the impact of my learned friend's position is that they can't organize collectively. And that is absolutely observed, especially when we note the very asymmetries in power that Dr. Figueroa highlighted in her opinion or in her position. And so it cannot be that alcaldes, leaders, are being told that they cannot come together to contend properly with the power of the state and also the disproportionate power of corporations. This sort of attack, Your Honors, is not new. It is not new that we see governments challenging the legitimacy of elected leaders, of traditional leaders. In fact, we would say that it is rooted in biases and prejudices that really just reflect the vestiges of colonialism within our communities. My learned senior complained to some extent about the fact that we are bringing grievances to the court, but we have barely touched the surface with the grievances, Your Honors. On the ground, the leaders face attacks on a daily basis. They are called illiterate, they are called incompetent, they are seen as being incapable of leading. And so these are aggressions, microaggressions, these are attacks on their capacity to really govern, to really represent their communities. And this, in fact, this position that is challenging their legitimacy and seeking to give primacy to some extent to NGOs is simply a reflection of that, Your Honors. And so on this point, what we say is that all that we are asking is for the court, and with the help of the experts, is to simply tell the government to stop, to focus on what they have to do, and let the representation of the Maya people be dealt with by the Maya people. They cannot be throwing their weight around when it comes to Maya representation. Furthermore, I just want to lastly say that this is a consent order. The parties entered into a settlement, and it cannot be possible that the appellants would have entered into a consent order, would have entered into a settlement, thinking or assuming or accepting that after entering into that settlement order, the government would be allowed to bring in non-functional organizations into the process and be imposing them on the other side. The government cannot impose who makes up the MLA, and certainly this was never envisioned when a settlement was arrived at. We consider this to be a blatant act of bad faith. The government knows very well with whom it is negotiating, and it cannot pretend that now, 7 years later, that issue is in any way contested, is in any way challenged or unsettled. It completely defies logic and any semblance of fairness to think, especially that at the behest of the opposing party, the appellant can be then made to include these organizations, that it does have legitimate concerns about the role that they are playing here, Your Honors. I also want to raise just one more concern about the jurisdiction that I know my learned senior raised in his statement. We do consider that the court does have the jurisdiction with respect to its supervisory jurisdiction to continue giving orders and to continue giving directions. When we are talking about the protection of the rights, the constitutional rights and the rights of the Maya people as indigenous peoples, we say that the remedial jurisdiction of this court under Section 20 has not waned simply because we are before this court within the context of the supervisory jurisdiction, because the court continues to be the custodian of constitutional rights, Your Honors. And so that continues to this day.
Yes, Ms. Brandes, I think we heard you. I think you spent a little more than 5 minutes, but okay, that's fine. Let me know. Let me now go to the other side. Opening statement, 5 minutes. Mr. Marshallek or Ms. Matut?
Yes, sorry. Yes, thank you, Your Honor. Your Honor, we of course don't agree with factual allegations being made, but we see no point into getting into further dispute over them. If we assume for one moment that everything they say is true, where does that leave us on this court? And how does this court, through any order that can conceivably make, seek to resolve those types of issues? The thing is, while there is a remedial jurisdiction, what the court cannot do is to order the parties to have trust and confidence in each other in embarking upon the process. That is something that has to be cultivated by the parties and nurtured and protected by them. That is, of course, not helped or assisted any with allegations of bad faith, with the kinds of disputes that have been raised. From my perspective, and I'm new to this, I just started reading the papers and seeing how best to navigate to a successful conclusion of the steps that need to be taken to comply with the consent order. And quite frankly, coming up on allegations of that nature and a dispute of that nature makes it nigh impossible to reach the end of the road here. So we need to get back to rebuilding the relationship and reestablishing, if possible, that trust and confidence in each other in pursuing the steps that need to be taken to achieve the objectives that we all agree must be achieved.
That's very clear, Mr. Marshallek, and I think all present would agree that we have to lower the temperature, maybe, and get back to a more practical working relationship between the parties, because that relationship has to be maintained, whether some like it or not. Let me just say this. I can say this about the point of jurisdiction of the court. Of course, it's an unknown territory in a way, but we are here to see if there is compliance with the implementation of the consent order. That is what this is about. That's why the court also asked the experts, when we were talking about the FPIC protocol, to see if what was on the table, what the government concluded, was in accordance with that consent order, because that is what we are checking. Now, it doesn't mean that it couldn't be better or that certain things could be changed, but the idea is that in the end, that FPIC order, that FPIC protocol is in compliance with the consent order. So that is one thing. We also have to recognize that although representation of the Maya people is an important issue, it is an issue that the court cannot decide. I think all parties agree with that. So whether or not the Maya people can come to some conclusion, up to now they have been represented by the MLA and the Toledo Alcaldes Association. And they, if they want to change that, that is up to them. But these are the two groups that are before us. And it is also a fact that they are the appellants. And of course, when we look at the implementation of a consent order, we have to realize that as we are a court of law, that there is res judicata between the parties. So the TAA and the MLA are parties in this process. And for that fact alone, they cannot be ignored, apart from the fact that they also represent Maya villages. Maybe there are other thoughts. That is not for the court to decide. That is up to the Maya people to decide. But fact is that these two groups are before the court together with the government. That is one thing. Another thing is that we really think that this exercise is a difficult one. It is not just like that the court ordered this compliance process, because we all knew from the very start that this would be a very difficult road to go. It is very nice to have the principles established in all its splendor, but to make that a reality in terms of the law is a different issue, and that is difficult. And we could expect these kind of troubles and problems to occur on our way to the final resolution of all these issues. So we have to keep that in mind. We are on the way, but we are not there yet. On the other hand, the court really thinks that through the cooperation of the parties, a lot has been achieved already. And we will come back to the FPIC protocol when we will shortly hear from the experts. But we think that FPIC protocol, whether perfect or not, might be a huge step forward. So that is an achievement. And other projects that are underway are also the result of cooperation. Whether it was good or cooperation, whether it was difficult, that is another issue. But those results, when we look back to 2015, we as a panel, compliance panel, we clearly have the impression that much progress has been made. And in order to make more progress, which is necessary, we have to really tone down the temperature, and we really have to get practical. And I'm sure that I'm confident from the words of Mr. Marshalek that he will try to get it back to that kind of lower temperature that we all need. We need to be practical. So that is what I think I would want to say at this point in time. There is another issue. I think the appellants asked to bring in another expert. We have indicated that we did not want to do that. This is not a litigation. This is a compliance process. We have 2 experts already, and we thought that for this exercise is enough. There's another thing that has to do with representation. I think it was announced that one of the other Maya groups, SATIM, would want to enter these proceedings. We have looked at that. I can tell you up front that is not what we are going to entertain, because it's not a procedure where you can intervene. That period is long behind us. It is just about the implementation of a decision between the parties that are before us. No other parties can interfere. The government, of course, can talk to all groups of Mayas if they wish. The only thing we are saying is, given the procedural position of the groups that are before us, the TAA and MLA, they can simply not be ignored. And I get the feeling from the statement of Mr. Marshalek that is certainly not the intention. If that is different, then we would like to know, but I don't think that is so. So that is what I would want to say at this point. But before I get to the FPIC protocol, where we want to hear a little bit from the experts, not too much, because they have written very readable and very clear opinions. But if my colleagues want to say at this point something, then they have the opportunity.
Chair, no, I think you have covered the ground exceedingly well. I have nothing to add at this stage. Thank you.
Same here, Chair. Thank you very much for the offer, but I have nothing to add at this stage. Thank you.
Yes, thank you. Okay, so about the AFPIC protocol. Now, the idea is the government has stated that, okay, this is a final document. We have filed it and it's now final. But, well, in life, nothing final is really final. But the point is this, or the question is this a document that would be workable for the time being? Because we must assume that the government will always try to see if things work out correctly, or if it doesn't, that they would be willing to make amendments in a document. So, so the question is this a workable document which is in accordance with international law? That is really the question. And we got the impression, we have read the expert reports very carefully, and we got the impression that the experts are really not very far apart. They may have some differences of opinion about representation, or they might have some differences about the clarity of the document, or that some things could be put in a better way. But basically, that is our impression. They are not very far apart. So may I invite Professor Solorio to ask or to answer the question that we have. Is that a correct impression that we have?
Well, thank you, Your Excellencies, for allowing me to participate in this process and also for inviting me to this hearing again. I just wanted to say a few brief remarks on this in response to your question. I do greatly appreciate that all of you as judges, they're encouraging this process to be more constructive, to lower the temperature, to be more practical. I think we all have the same interest in mind, right? We're trying to advance the rights of the Maya indigenous peoples, and also to achieve the proper compliance of the CCJ consent order. So please take what I said in my expert opinion, and also what I'm about to say, in thinking how can the CCJ consent order be properly implemented, and how the AFPIC protocol can be an adequate tool for this purpose, right? So a lot of the comments that I made are based on international law, but it's also very shaped by the 12 reports that I've already adopted as Independent Resolution Authority, the visit that I undertook, and all of the conversations I had with the Maya villages, the follow-up also requests that I've done with the government, and my observations of the dynamics between the parties in this case. While I recognize when you look at the protocol, there's a cognizable effort, right, from the government to make sure that there's language that's in conformity with international law, that advances or motivates or promotes, that compliance with the CCJ consent order. There are 5 specific issues that for me are warning signs. And they're warning signs in the sense that if they're not modified in some way, I have a feeling that this tool is going to have a lot of problems in its implementation on the ground based on the experience that we've already had. Which means that this is going to be a barrier, to have proper compliance with the CCJ consent order, which is what we're trying to achieve here. And I just want to say very briefly something about those 5 components. The representation issue is major in this particular case. We've had ample discussion in these hearings about the representation issue. And it's very clear in international law that the Maya people should be the one choosing their representation, during consultation and consent processes. So any language in the AFPIC protocol related to representation should be drafted by the Maya peoples. I don't think the government should be getting involved in this particular aspect at all. And that's something that really, I would suggest, needs to be addressed pretty as a priority matter when it comes to this protocol. The other aspect is the title. The reality is that we're in a context where every time I've met with multiple government authorities, I've met with the villages. I mean, I've been to the ground, but also I've been able to review all these concluding reports and complaints. And there's a lot of confusion as to what consultation is, even that connection between consultation and consent. And the trend, the weight of authority, the orientation of international law is that informed consent is needed, right? And I think having that signal in the title is paramount. I mean, the reality is that this is also a practical document. It's a training document, right? When we're thinking of that practical component, which I think is very important that U.S. excellencies have this in mind and that you're motivating us to all be practical. And I think having a title that just says consultation is sending the wrong signal. The reality is that numerous government actors are going to review this protocol. Third-party actors are probably going to review this protocol as well. We've seen in the concluding reports all these third-party actors that are involved in these processes. You want to send a clear signal that the goal is to achieve consent. And I'm afraid of a title, especially in this moment in international law, that just says consultation. And I think also that connection between consultation and consent, I would like to see it more clearly stated in the protocol. I mean, the reality is that this is an enormous challenge, in the Belizean context. We've seen it in the 12 concluding reports. And I think this is not a minor issue as well. I do think that requirement to notify the Maya when there's any sort of potential limitation of rights in times of emergency, this is not a minor issue either. And there's very clear international law in that regard, at least notification, right, of potential limitation of rights and the justification and how long. And lastly, I do think, considering that we have received complaints related to U.S. capital activities and other corporations and many third-party actors, I do think that having and including explicitly those investment, tourism, and economic development projects as part of this protocol, especially what we know already in this context, I think is very important as well. Of course, the government is the one that has the lead with the Maya when it comes to consultation processes. But I think it's very important that those third-party actors are involved too, because this is also training for them. I think one of the most important values of having an FPIC protocol is the ability to train, right? To train third-party actors and corporations in terms of what their obligations are. We do have precedent in international law. We have the United Nations Ruggie Principles, in which corporations and third-party actors are not supposed to do any harm, right? They're also supposed to provide remedies, and the state has a due diligence obligation to supervise what these private actors are doing as well. And just two final thoughts. I don't want to take too much time, and of course, I'm always very open to any questions that you have. I think a climate of confidence is incredibly critical in this process. And for me, the biggest concern that I have right now is that I'm not seeing a climate of confidence. There has to be steps and measures to make sure that there's confidence, that there's consensus, that there's dialogue, that there's a positive disposition to be able for this FPIC protocol to work. The way this FPIC protocol has been managed, the fact that the CCJ received this FPIC protocol from one side while the other side is very unhappy with the protocol, for me, it's concerning, because the reality is that you can have an amazing document, but if there's no confidence in the document, there's no trust between the parties, we're going to have a problem with implementing that document. We see this problem in international law. We see this problem in national laws. We have beautiful national laws. We have beautiful international law. And it has so many challenges when it comes to compliance, because at the end of the day, it really depends on that trust and confidence between the parties. So I think it's extremely important, that there is a process in which whatever protocol is used and considered approved has the signature of both parties. I think it's very important for the Maya to participate, and propose language and work on language related to that final protocol. I think this is all paramount to be able for this protocol to work at the end of the day. And I think even though these may sound like minor issues, at the end of the day, I think we're going to have a lot of implementation issues, when it comes to the CCJ consent order and paragraph 4, if some modifications, not only on the language of the protocol, but in the process that we have been seeing, are not addressed. I don't think these are minor issues, and I'm afraid that we're going to come back in a future hearing, Your Excellencies, and say, oh, we have this protocol, but look at all the problems and challenges with its implementation if we don't address some of the language issues that we're seeing, and also the context and the process, to consider that a protocol has ended. I mean, precisely, this is what we talk about in international law, about informed consultation and consent, process of dialogue, consensus, trust, confidence building, effective participation, from indigenous peoples. This is why we have developed all these principles. And even the conclusion of this protocol and the approval of this protocol needs to reflect those principles as well, including the language modifications that I've suggested in my humble expert opinion. Thank you so much, as usual, for the opportunity, and I'm very open to any questions that you have.
Yes, well, before we go to Dr. Figueroa, I think we hear you. We understand what you're saying. The question that we might have is, okay, well, we got the impression that at least, maybe imperfect as it is a huge step forward compared to what we have now, namely nothing. Would you share that impression or not?
Unfortunately, Your Excellency, I don't share that impression, especially because of the experience that we've had already with the complaints and reports in this process. I even visited the villages. I've seen the complexity. I keep on receiving complaints. Even sometimes I've issued more than one report, when it comes to a village. So, and we have a historical problem of disenfranchisement. And we have so many compliance problems as it is, that for me, even though I laud and recognize the effort of the government, and I've always done that in these hearings, I've always come forward and said, the government is taking important steps, and I think the government is still taking important steps. I think it's very important also to recognize when we have voice, especially when we know there are dangers of potential massive and systemic problems when it comes to compliance. And the document as is, I think, is going to have a problem with honoring that CCJ consent order, paragraph 4. And for me, at least that's my interpretation and my opinion. And thank you for the opportunity.
But as we see this as a work in progress, because even if the document was perfect, as you see it, then you would still say, well, yeah, that's nice to have a perfect document, but if there is no trust, then it will not work either. So, so it comes down to that. So the point is this also, that's another, without seeing this as the final document, but at least if you have something which you could try out, if there is more trust, then it might work to a certain extent. That is at least what you could think. The point is this: if I don't know what the other part, but the other party seems to be pretty clear that for them this, for now, is their final document, and so then we can discuss for another year. If there should be additions or not, but if there is unwillingness to do that, then we also wonder, okay, what good will that do? Because then you will get a status quo which makes things even worse. So yeah, so it's probably a choice between two evils, if you want to say that. I am. If my colleagues have any questions, they will ask, but if not, then I will ask Dr. Figueroa to, in a very short way, react on what we have heard from you. Yes, Dr. Figueroa, welcome.
Thank you, and good morning.
Good morning.
Thank you for the opportunity to be here. Well, very briefly, my position is already stated in the document, but I would like to address what I see as the critical issue with the protocol, with the issue of representativeness. And just to clarify that at no time does the protocol prevent the participation or the representativeness of the Toledo Alcaldes Association, totally the opposite, the contrary. The idea is to leave room for the alcaldes to decide what to do in terms of representation. The alcaldes not only have the right to organize themselves, but from a point of view, they must do so in order to face the great challenge that they face in this world. However, and from my point of view and experience, this process of strengthening the alcalde organization is a political one, and it's not legal. And the reason for that is that if we leave for the government to establish in a document, in a legal document, who is to represent the alcaldes politically, we have no guarantees that tomorrow, when the government changes, the government might create a parallel indigenous organization and establish that by law. Again, no, that has happened in the region. I work 25 years around here. That has happened everywhere. When the government doesn't want to talk with the legitimate organizations, they create a parallel one by law. No? So the idea was that, and if at some point there is a political decision that the Toledo or any other organization, no, I'm not from there to decide. That will be the voice that they have to talk. Well, the government will have to respect that. I don't see at any point in the protocol that there is any hindrance for the participation of the Toledo Alcalde organization, and I agree, it has not to be the final document, as you said, Your Honor. I believe we have to see this as the first final document. It has to be seen and implemented from a point of view as a living document. This document will have to change and to be amended according to the Maya political process, but all of those issues, they're not to be solved in legal venues, no, but they are for the organizations to decide by themselves, and that's my only.
Yes, well, the good faith point is crucial in this protocol also, yeah, from a civil law perspective, that is all-encompassing. And I thought that was clear in this document. So, good faith, yeah, that has to go down to trust and etc. People of goodwill, and we cannot force that. But as you say, you see it as a document that we could work with, that the people could work with, and see how it goes. Professor Solorio has, of course, some experience as the authority, so she may have some doubts, or she expressed that if it will work. But I think you are not really far apart. I think you both share the same international standards that have to be applied here. I got the impression, and clearly, although it's called consultation, the document clearly makes clear that in the end it goes to consent. You can have consultation, but that is not enough. So anyone who thinks that, okay, as long as we are in some form of consultation, we're good, that is not so. There needs to be a consent or no consent, and then that will be the end of the matter. I think that I have understood the protocol to say that. Is that so?
Yes, yes, sure. And the name in different parts of the world, they change. I don't see the name being a big issue, actually. I believe it's much more important to see what does the protocol does. And I say it again, it's the first time, and I work together with indigenous organizations on consultation process. This is the only protocol that protects the right of indigenous people to dissent, to say no to a project. There is no other policy or legal tool in the America that Belize is the first country to do this. So it is amazing. the results, and it is the result of the fighting of the appellants, actually. So it is a result.
If I may, Chair,
Sure.
thank you very much, Dr. Figueroa. I thought I learned a lot from your inputs, as I did from Professor Solerio. The issue of representation is, of course, the elephant in the room, and I agree entirely with the chair that I don't think that can be solved by us. Certainly can't be solved this morning, but I think we have to put our heads together and see how best we can come up with a solution. I do take entirely what Ms. Mendez said earlier. I understand from the government, however, that there may be other Mayan entities which may wish to, in a sense, go their own way. I would be very, very keen to see how that can be brought together, consistent with the international law norms. So, as I said, I think that is a big issue which has to be addressed. But if we leave that off for the time being and just look at the other matters, which might be easier, and Ms. Mendez mentioned at least two of those, which I think were repeated and expanded on by the authority. One was the question of consent, and you have engaged with the chairman about this already. If it doesn't mean that much to you from your standpoint, what is the harm in changing the title so that it indicates that consent is required? Is that something that could be done before there's any further advance on the implementation or sensitization to the protocol?
Well, the name of the protocol is not regulated by international law. There is no international standard that says that the protocol has to be called consultation or consent. No, yes. That was part of a discussion, internal discussion in the government. And my concern when I was advising the government was to make clear the words. So we started a conversation about how some of the words would be translated to the Quechua and Mopan, and that was. It was the result of a good faith intent, to create a name that would be easier for the Mopan and Quechua to understand, and that this process of thinking about the translation of the legal terms, that is part of international standard because it's part of cultural appropriate methods of communicating legal standards. So there is no, in any document of the international organization says that the protocol has to have this name or that name.
No, so I think, not to interrupt you,
yes.
Professor, but I do understand and I agree with you. But at the same time, the norm in international law is that the consent of indigenous peoples is required. No. Except, of course, in some extraordinary circumstances, which we'll come to in a minute. So what I'm asking is, since the MLA, since the TAA, and so many of the Mayan people that they represent would prefer if consent was in the title of the protocol. I'm just wondering whether there's a big obstacle to doing that from your point of view.
No, that's what I'm saying. This is not a legal issue. This is a political issue. All those issues, no, it's not for a legal expert to answer because that would be for the government and appellants and for the government and my organizations to decide whether it's going to call this name or that name. I believe that my role here is to make sure that that the wording of the protocol are according to international law. I wasn't responsible for the whole document, as you might recall. When I got into this process, there was already a draft. So I took the draft and I tried to improve the draft without changing the structure of the draft, like without making starting a new one from scratch. But those issues, from my point of view, I can explain the legal rationale, the legal reasons that are behind it, but I cannot decide on them. The final decision.
Okay. Yes,
But you are
listening.
saying,
Sorry, Chair, go ahead.
yeah, if I may. So you're saying there's no legal obstacle against either consultation or consent. There's no legal obstacle.
No.
It's might be a political obstacle, but not a legal one. Is that more or less what you're saying? Yes, Justice Anderson.
Yes, so that if the Mayan people would prefer the inclusion of the word consent, ultimately it's a matter for agreement between the parties. I understand that clearly, but from your point of view, there's no real legal obstacle to including.
No,
Okay,
even
what
some,
about
there are some protocols that brings both name protocols for consultation and consent. So,
right. So that's an area. That's an area where there could be some negotiations. Okay.
Yeah.
What about the other areas mentioned by Professor Solorio to do, for example, with tightening the connection between consultation and consent in the actual document? Is that somewhere? Because I noticed in the FPIC that you do say that consent is required. So is there any room for sort of looking again at the language and trying to see whether those two concepts could be brought together more? So that's one thing that she mentioned. She also mentioned the notification process. And I think this is particularly in relation to emergencies and where the rights which would ordinarily be given under the protocol are mitigated by virtue of the emergency. Notification of that to the Mayan people. And then finally, I think she mentioned something about the investment projects and making a specific reference to those. So those seem to me, as I said, I think representation is a difficulty, so we could always come back to that. But these other points, could they not be accommodated relatively easily, I would have thought, in just sort of tweaking, if you will, the protocol, the draft?
Well, I believe some of them could be accommodated. Some of them are issue of wording, for instance, to say that consultation has to seek consent. Well, yes, we can. I mean, I don't see how that would bring substantial change, but I don't see any problem adding that as well. I believe that the issue of private investments is out of scope of the protocol, because the protocol is designed for relationship between the Maya people and the government, and private relationships are nothing to do with this protocol. They're private relations, like any private person has to deal with the Maya village as a private person as well. Like if someone wants to make an investment in my home, they have to deal with me as a owner of my home. So those are different issues, completely different issues. We cannot deal with them in the protocol. Related to the emergency, I believe, I'm not sure, and that's because of my ignorance. I'm not sure if the legislation of Belize, how that would, because there will be another legislation related to information on state of emergency. And this is a policy. So from a civil law perspective, that could be tension, because a policy cannot go against a law. And I believe this is an issue regulated in Belize. So I'm not sure about this state of emergency.
Yes.
Yes. Dr. Figueroa, I want to go back to that point that you made about the private parties or private entities. I believe Professor Solorio referred to them as third parties who might wish to invest or so, investment, tourism, and the like. Would there be any harm whatsoever in putting that into the protocol? Putting that, I understand that you say if someone wants to deal with your parcel of land, they will deal with you personally. But could there be any harm in sending the message to the third parties? Because we've been at this matter for 7 years now. We've heard a lot of complaints about third parties and various allegations of what has been done in various villages. Could there be any harm in putting that in? And of course, putting it in any other laws? that may be, or any other documents, I don't know, down the line, but certainly here in the FPIC, because that seems to be a big issue here.
Yes, because of the source of the relationship is different. For instance, if we're talking about the consultation, the process between the government and the village, the Maya village, it's because the Maya village holds the title. It will hold the title soon, hopefully. But the government, the state of Belize, has some right over being in the subsoil or forestry, or has to regulate any kind of right that that is inside that property. No, so they have exclusive rights, but also in some circumstances, the government might want to develop oil or mining or a protected area, or in those cases, the Maya village, they cannot say, government, we don't want you here because the state has rights over some portions of that territory, of that land. So the consultation, the process of consultation was developed to do that, to create this dialogue and to try to solve this superposition of one title and another title. But in the case of private parties, if for instance, if I want to develop a tourist project in a Maya land, I have no right. No, I have nothing to do there. So I have to ask the permission. I cannot have any expectation that the Maya will allow me to develop anything there, because it's not, nobody said to me that I have a right in their land. So the source of this private relationship will not be the same of that between the government of Belize and the Maya village. And that's why the international law says that when the government has an interest, but a right interest on the Maya land, on any indigenous land, it has to consult before approve any administrative decision. A private relationship has nothing to do with any administrative decision on part of the government.
Okay, I think we read somewhere that there was an intention that you would have a meeting with the alcaldes, or at least with some Maya groups. That there was a date, but that was not convenient. Have you heard about this? Will there be a meeting, or have you had a meeting with them?
I couldn't meet with the Toledo Alcaldes Association because they asked for a meet. I was in Belize. I was in Punta Gorda in Toledo. I left last Thursday, and they couldn't meet Thursday, so they asked for me to be on Monday. But I was already here in Colombia by Monday. So we couldn't meet.
Okay, but that might still happen. At least you are willing, certainly willing to meet with them.
Sure.
Excellent. Okay, thank you. That is it for now, I think.
Chair, if I may, so yes, sure. In relation to the FPIC protocol, then I think the chair indicated that we would be very pleased if there could be some action on this. 7 years is a long time, and we need to progress. Now, I think the question is whether, and this is directed, I presume, to the government more than to Dr. Figueroa, whether there could be a meeting between the Mayas and the Maya representatives and the government with a view to doing a bit of the tweaking that we discussed to the protocol before it is further sensitized amongst the Mayan population and before it is implemented. Would that be something that the government would consider, would entertain? Because we would obviously want, we can't dictate, of course, as the chair said, but we would want as much as possible, based on what the authority said earlier, for the protocol to come into effect and be operationalized in the context of, mutual trust and confidence. And as we heard earlier this morning, there's a deficit in that at the moment. And perhaps a meeting where some of these issues where, Dr. Figueroa indicated there is bigger room for negotiations, perhaps that would help to build a bit of the trust and the confidence. Is that something that the government will be open to before fully operationalizing the protocol?
I think that is a question for Mr. Marshallek. And I want to add to that, okay, we can look at this as a purely legal issue. The tweaks that, well, have been discussed are not really essential as I see it, but it's also true that even if this is a perfect document, it will not work if you do not get some form of trust, some form of buy-in, which is very important. So, Mr. Marshall, like you're a lawyer with many years of experience, so I don't have to explain this to you. We would think, but anyway, that it's up to the government, but with some adjustments, some tweaks, it might be that you will get to a text that we can work with, and it will certainly probably not satisfy totally the other side. But the point is this: we cannot, my favorite saying is, "Let the perfect not be the enemy of the good." And there's also an understanding that, okay, well, what the government calls a final document is also a document that needs to be tested and see how it goes. Because in the end, we want something that works. I cannot imagine that the government wants it not to work. And as Dr. Figueroa has said, you have a document here which goes way beyond what we have in South America. So in fact, it is really worthwhile. I even think of, from a political point of view, to have something that works, because that will put you way in front of many other countries. That is not the most important thing. But anyway, so the question is, would there be some way of dealing with this to get started with the protocol? If some tweaks might get the other side to the point of saying, okay, let's, for the time being, working with it, let's see how it goes. That is the practical view that we have. Then we would make, or you would make, enormous progress. So that is the question. Is there any will to at least consider this?
As I understand it, Your Honor, this particular protocol is an interim measure and falls away in any event when the legislative framework is put in place.
Yes.
Testing it and see how it works, and then refining it through that process is a better approach. But my concern is this: I don't think the court should be seen as taking sides, using moral suasion or other, in what is purely a political matter. I don't think it will help the relationship between parties. The parties are always free to come together and to negotiate and agree. But I think if the court starts intervening in those aspects and leaning one way or the other on the parties, even though not with any compulsive order, what it will do is just encourage this kind of disputes coming back before you in the future. The parties need to come together, and they need to be able to talk to each other about these things without running here making the kind of allegations that have been made. it doesn't help matters, and it puts the court in a rather delicate position. So that is my concern so far as that suggestion. Of course, the parties can meet and agree. And if they agree to quick tweaks, that would be a very happy scenario. But what we are getting here is an attempt to have the court lean on one side or the other to impose entirely the will of one party on the other. And that will not improve the relationship, the negotiating relationship, as the parties have called it, as the appellants have called it, between the parties. So
Mr.
that's
Marshall,
my concern. But
yes,
I
yeah,
do
Mr.
respect.
Marshall, let me get to that point right away. We are simply trying to be practical here. As you know, we are not imposing anything, but if we would see that you could make progress, because that's the only thing that we are looking at, progress, making progress. That is the most important thing. So we are just asking, is the government prepared, if the other side wants to speak about that, to at least look at some tweaks? We are not asking you to deviate from any principles or whatever. That's all the government's business. The point is, this is a common effort to make things work. And that is the only way you have to see it. The court has decided in the 2015 judgment, that it gives its blessing to the consent order. So that's what we are looking at. So, to make it very clear, we are not really favorite of listening to all kind of grievances. We also agree that really parties should discuss that among themselves. So we have heard grievances or read about them from both sides, and we don't want to spend too much time on that. What we want is look at the content and how do we get progress. And I think that that is in the interest of everybody. As soon as we can end our compliance exercise, the better for you, and certainly for us too.
Yes, sure. Could I just add to that as well? In terms of the tweaks, if you were to accommodate such a meeting, and if the applicants or the appellants attended, and if you came to an agreement, what's the harm then in indicating that the MLA and the TAA have consented to this FPIC? Again, I don't know it's going to solve all of the representation problems, but I'm just asking whether that might not be a way of, again, which I'm sure everybody here would want to see built, trust and confidence. So you could add that to your answer, please, Mr. Marshall.
Yes, no, I don't think the government has ever been adverse to meeting and discussing tweaks. What I think is the problem.
Sorry, I didn't hear what you said. Could you repeat that a bit louder?
Sorry, I say I don't think the government has ever been adverse to meeting to discuss the possibility of tweaks. I think the issue here arises from the fact that the protocol, the draft which originated from the other side, was reviewed and revised by the government, went through its processes, and went through all its approval processes on the government side. So it's final on the government side. So if you're going to embark on renegotiating at this stage, you also have to embark on all those processes again within government to get it approved. The draft as it exists, we see as a major step forward. We thought we were making major advancements and agreeing to most of what was there. Sending it back through that process to change a title, to make the kinds of tweaks that is being suggested, might well, I don't know that it will be favorably received, but embarking on an attempt is something that I think the state is prepared to do. We're prepared to try to improve relations and have the parties feel freer to talk to each other about these problems. At the end of the day, I think, listening to Professor Solorio, I think the problems that she envisages arises not so much from the policy as from the state of the relationship between the parties. The policy is a good one. What we have is one party trying to use these proceedings to impose its will on the other, not an attempt to negotiate, an attempt to get us scolded and pushed in one direction or another. Now that you're using the legal process to interfere with political relationships, and that's a tricky area. I don't even want to engage in that. My brief when I took this on, and my instructions was to get that roadmap agreed and to drive it to conclusion. That's where, because I want this brief to come to an end too. I don't want to retire with these hearings coming back before the court. And when we engage in this kind of fine tuning, I think we run the danger of prolonging it unnecessarily, and I mean for years, because I've accepted that everybody will not be happy with any outcome, regardless of how good it is. And to strive for perfection is fine, that's good. To achieve it, I'm not so sure it's possible. So we need a good starting point as we need a good foundation, not a perfect one, from which we can build the superstructures and eventually reach that perfect phase. But I don't know that we can do that in this context. And I don't know that we can resolve and solve all the relationship issues in this context. But we can certainly try to get something decent on the ground and functioning. And then whatever future challenges or whatever future political processes are used to fine-tune and tweak it, we use it and eventually reach that place. And that's how I see it.
Okay, well, we have to leave that process to the parties. We are here just to guide or give our ideas how you could reach to the next step. That's the only thing that really is of interest in this capacity of the court. Ms. Mendes, so you've heard what has been said. We still think that the main thing is, apart from words about consultation, that it is more than clear that in the end, it is all about consent. It's a process, it's consultation process, but in the end, consent needs to be gotten from the village, etc. So Mr. Marshallek is willing to see if some tweaks can be made, but he's not completely sure if that will be if that will happen. On the other hand, you could also say, well, we read the protocol against the background of the comments of both experts, which clearly make it very clear that in the end, consent needs to be gotten. I also know that there was in your proposal something about notification of I think the TAA, that when a problem occurred. Okay, well, we can understand that from your perspective, but then on the other hand, if there is something proposed to a certain village, every village has an alcalde, and he is a member of the TAA. So if the alcalde thinks that he needs some support from the TAA or the other groups, he will inform them. So in a practical sense, that doesn't have to be that much of a problem. But the point is this, I think the best thing would be if both parties would agree to discuss this and make a real effort to see if some tweaks could be made in the protocol. But if that somehow is not possible, then we can stay in this dispute for ages. It doesn't help anyone. We have heard, and that is an important thing, okay, it is final, but not final. It's final for now. But the government has said we are willing, that is how I understand it, we are willing to see how it works, because in the end it must work. And if it doesn't work or problems occur, then we have to make changes. So that is there. So now we can fight about every letter of this protocol, but it will not help the Maya people. We could also say, well, let's give it a trial, a fair try. And having read the protocol in the terminology of both experts, who make it very clear that consent, or even no consent, you can refuse, is required before any project can take place. I think that is we think that that is very important, and that is not in place now. So if you have that in place, at least you made a huge step forward. Maybe not perfect, maybe not, maybe it will give problems, but that's the matter of life. It will always give problems. So that is the other side of this case. So we suggest, okay, let's see if you can get to some agreement, but if you can't, just start applying the protocol and see how it goes, and let us know. We will be kept abreast if it works, or if it doesn't work, why not, etc. But we cannot stand still here. So that would be our take, I think, on this point. Is there anything you want to say to that, Ms. Mendes?
Yes, Your Honors. I do hope that Your Honors do appreciate the complications on the ground and the ways in which those dynamics do have significant impact on the consent process. Yes, Your Honor.
That from the very start. That's why we have compliance sessions. We know how difficult it's going to be.
Yes, yeah. If I may just speak even just 2 minutes, I just want to make the point that even as I think that no entity, nobody, no person here is more motivated to get this implemented more than the Maya communities. But in that context, I do think that we can have perhaps inadvertent, perhaps intentional harmful effects on the community in the manner in which we are implementing. And so I do understand the court's frustration and perhaps even discomfort about the grievances that are being raised. I am also not completely comfortable with them being raised and getting in the mud, so to speak. But these grievances are grievances that are directly impacting the implementation process. And so I just want to make the point, because there is a tenor in the manner in which we are receiving at least the input from the appellants, as if this is somewhat petty. Your Honors, the appellants have given concessions time and time again. What has been presented in the FPIC protocol is not something that we are here strongholding the government. Can you imagine? The government has bulldozed this protocol through all of the objections. And so I think that I really need to make that very clear, because if we are talking about building trust, rebuilding confidence, that relationship didn't break down in a vacuum. That relationship brought down because of a very particular context. And these are communities in struggle. And so this is the only forum that we can bring certain grievances. And as I've mentioned, it is not all grievances that we bring to the court. And so I think that we have to understand that there are a lot of interests impacting these communities. These are fundamentally communities in struggle. And in our view, the issue of representation, as Professor Solorio mentioned, is a major one. I would agree, and I welcome the suggestion for the parties to sit down to see what tweaks can be made. But in framing them as tweaks, I don't want the impression to go on as if it is unimportant. Some of these tweaks directly impact rights, Your Honors. There is an imposition in the change of the customary decision-making process, which I'm sure both experts would deem as sacrosanct. Some of the requirements in the customary decision-making process, which both parties agree is fundamental to a protocol, has been changed by the government without the consent of the communities. And so I do think that what is pending can be agreed, but nowhere in the customary process of the communities do you see that they are saying that 60% must consent. And that is a specific prescriptive requirement that is included in the protocol, which we say cannot be included in the protocol without the consent. I welcome the suggestion from the court for the parties to meet. I do not think that the position should be that because we certainly are very eager to get outcomes out of this process, we should enable a situation that basically fatigues us into consenting or fatigues us into simply being grateful. I make the point because I want the court to understand that this is not just about a change in protocol, in names, sorry. These are a couple substantive issues that can be worked out, but that are fundamental. And I think if we're talking about building trust and building good faith, then I think both sides should also show that the relationship did not break down in a vacuum. And I do think that there is a certain impression that what is happening is that the appellants are trying to, in a way, impose things on the government. I think all we are trying to do is ensure that everything that comes out of this process is robust and is rights compliant. Thank you, Your Honors.
Sure. Yeah, thank you very much. Yeah, that is all clear. The point is, you could go on for ages, but we are not saying that the grievances are not important or it's all nonsense. Certainly not. The point is that if we are going too deep into all of that, it's not helpful. And so we have to try to recalibrate, if you wish, the conversation and try to get back on track. And for example, even if you would say, okay, well, let's try this arrangement, because we don't get the impression that it is, that clearly the protocol also requires consent. So the tweaks are tweaks because they clarify more than anything else. But if you call it a consultation protocol, it is clear from the protocol, and that is required also in the consent order, that it needs to amount to consent in the end. So that is fundamental. And then the name, well, may give a certain impression, wrong impression. That is a matter of clarification or taking away some doubts that you might have. But basically, that is what the protocol says. You need to get consent from the separate villages and so on when you want to do a project or when you want to give leave to do such a thing. So that alone is enormous progress, we would have thought. So we would say give this a try. And even if you would say, okay, well, we go along for the time being, that could be, you would say, well, all rights reserved, but we will try and see how it goes. We have our doubts, maybe you have your doubts, but we will see if it works. If it does work, fine. If it doesn't work, we will make the point, and then we'll see what is going to happen with that. But the point is we cannot stand still. We have to make progress. And in the end, I have to make that clear, this is all about compliance. It's a work in progress, so it's not fixed. There's much more to do to get to the end result. But if the end result is not of your liking, and we are not there at all, then there's always the way of litigation. So we are not going to express any opinions what is good or not, because there might always be litigation coming, and we are not going to express any opinion. What we are doing is trying to guide the process towards a solution that is to the satisfaction of all and which will avoid litigation, because litigation is in nobody's interest. But if it has to happen, it has to happen, which we try to avoid. So let's look at that from that perspective.
The communities will forever be in court, Your Honors.
Excuse me?
The communities would forever be in court if it is that, in our view, we don't take some more proactive steps to ensure
Sure,
that there is rights compliance. Again, we are looking at something that is here for 30 years.
Yeah.
And so I understand the need to focus on progress. There's nobody else that wants to progress here. But yeah, that is a risk. That is a risk here, and we do think that it is within the supervisory jurisdiction of the court to not take such a restrictive approach. And I guess in that sense, it's on us to perhaps explore the liberty to apply, which is also included in the consent order, or something like that, because we certainly would not want the communities to forever be before the court when there's a glaring inconsistency with their rights. And I say that because of the point that I made with respect to the customary decision-making process.
Okay, well, we are not going to interfere with whatever you think needs to be done. What we're trying to do is to guide you through this process, which is difficult enough. But any other decision that you would take, it's up to you. But you have to be clear that even if you apply a liberty to apply, is just to clarify certain issues. It's not new litigation that you can start under that. You know that. So there is plenty opportunity enough to consider those kind of routes. But let's first, and again, be practical and see how far we get. Maybe it's not that bad. Maybe it is, maybe it isn't. But that is all up to you to decide what is your strategy. We have to guide this process. That is what we are doing, as good as we can. Okay, so that.
And we are not requiring. We can't require a meeting, but we would be happy if there was a meeting between the two sides to see if any further consensus could be developed around the FPIC. I think that would be a good step, and we recommend it, but of course we can't require.
Chair, if I may, I understood from the beginning that I think nearly every speaker spoke about trust and confidence and the building of it. I'm not sure the courthouse is a good place to do that, having been a judge now for some 20 plus years. But I do hope that these parties, for the good of their people, and all the people of Belize, can really get together and work this out. Because we have a long way to go. I'm looking here at the very many things to be done. Revised roadmap, legislative drafting process, auto delimitation. Mr. Marshall-elect, Ms. Mendez, you have a lot of work to do. Maya customary land tenure policy. You need to have some understanding and agreement on this issue of representation, this thorny elephant in the room, if I may call it that. You need to come to some agreement on it to move forward, or else I'm afraid I'll be long gone from the CCJ and you all will still be at it. But I just trust that that will not be so. that every effort will be made, as Justice Anderson mentioned, my brother, to come together, because Mr. Marshallek and Ms. Mendez, if you are able to do that for this protocol, life will be a lot easier down the road. But if you don't do this, well, I don't even want to think about what the future holds. So just thank you, Chair.
You mentioned you've been gone from the court, my sister judge, but I think many of us probably would be gone as well. People like Mr. Marshallek, people like Justice Witt, people like Justice Anderson, I think we'd all be gone. Just a few, just a few left. So please, for everybody's sake, let's try and make some progress. Huh?
Okay, so we close off this point. We have said what we think we have to say, and it is up to you to decide what wisdom is. Then there are, as Justice Reginald mentioned, there are many other issues that we would need to look at. I do think we will. We have half an hour left to go, and then we should close it off. There is the revised roadmap. There is the legislative drafting process. Third parties conflicts. We spoke about that a little bit. Auto delimitation issue. Maya customary land tenure policy. Then there is a smaller issue. The contract of the authority. Has that point been? That last point has been settled or not? Professor Solorio, are you still on as the authority or?
Thank you, Your Excellency. Just to give you an update, I'm de facto in the position. Unfortunately, I haven't been able to sign a new contract because there's housekeeping matters that haven't been taken care of by the government. We are in communication. I'm not sure where those matters are. I'm still willing to serve in the capacity, and I'm still serving in the capacity de facto, but unfortunately, I haven't been able to sign a contract due to those pending housekeeping matters.
Okay. Ms. Matut, can we expect some action on that point?
Yes, Your Honor. The Chief Executive Officer tells me that it's in process. So it's already been pushed off. It should come out the other end of that. In a couple of weeks, 2 weeks or so. Okay. So we expect that to be done.
That will be resolved. Okay, thank you, Professor. So the other issues that I mentioned, we have half an hour. Ms. Mendez, are there some of those issues maybe are more maybe more pressing than others? Could you indicate what is a pressing matter for you that you want to discuss of all those other issues that we need to look at?
Well, Your Honors, I would think that the roadmap is something that needs to be dealt with.
Okay,
but not at this point, Your Honors, but to be quite frank, I'm not too sure where we are now. Is it that we cannot here agree or the court cannot direct deadlines and ask the parties to meet? Because with respect to the roadmap is quite a comprehensive revision of the December 2018 agreement. And this has already come up before the court with respect to the need for there to be agreement for any revisions. We would like to know then when the parties can meet and what really is the foundation through which the respondents seek to engage us with respect to this. We have already communicated some of the concerns that we have, but I do think that we would need some guidance from the court as to how the parties will now be in dialogue. Because again, the other elephant in the room is the lack of confidence. And so we want to know, will we meet, or is it something that consultation and consent is being perceived as being sent via email and for us to provide our inputs. We have provided some inputs.
Yes,
I think that then there's a need then to meet. And again, that the framework through which the parties will be discussing and meeting still takes us back to the issue of representation, and that is what has complicated this, because we want to know what is our standing when you're talking about this negotiating process. We have made it very clear that I think that the strategy of the government right now is to really gut our negotiating leverage, because there seems to not be a requirement to consent or for there to be any agreement as we are seeing.
Ms. Mendez, I really don't mean to interrupt you, but I think we get the gist of where you're going. And the basic point is that you consider a meeting would be very helpful. And I think we do as well. So it's simply a matter of deciding on the meeting. Now, we have never mandated or required. We have consulted with the parties to see when would be a convenient date for both sides to meet. And we have recorded that. So it seems to me that if a meeting can be held in relation to the FPIC protocol, you could use that meeting to discuss this other issue of as well of the roadmap. Was that the document that was sent to you, but there wasn't a response because the time that was given was you thought too short?
Yes, that was the second document that was filed.
Right.
Yeah.
So obviously, I would imagine the government would expect that there would be some meeting to have a look at the views that you have put forward. So why not use the occasion to talk about the two issues we have spoken about this morning? Would that be acceptable to you, Ms. Mendez?
We will see how that goes, Your Honors. I guess for us, the frustration is that we have engaged the government on the issue of representation, which is why we have brought this before the court. And the point really is that we want to know what the rules of engagement. Is it that the government is recognizing that in order for there to be a revision of the 2018 agreement, there will have to be consent, meaning the parties, as we understand them, we will have to agree to those revisions. That has been somewhat uncertain. So that's the point that I was seeking to make. But I understand, yes, that the court has always asked the parties if we can agree, if we can set a deadline. So yeah, we welcome having the ability to meet with them. I just wanted to highlight the uncertainty in going into that arrangement.
Well, if you were to go into that meeting and you were to agree with the government, then there's no problem, is there?
Then there is no problem, but there are serious concerns coming up from that roadmap. But yes, then there is no problem.
There's no problem. And if you go into the meeting and you don't agree, then of course we have another opportunity to discuss it here or elsewhere, as you indicated. So it seems to me that one way or the other, instead of going with the precondition that you have to have the consent to modify the earlier agreement, why not have the meeting and then see where you go? Because you might surprise yourself and you might find that you agree with the outcome of the meeting. So why not going in that spirit, as everybody has said earlier, with a lowered temperature and in good faith. And I saw that you made a note of that phrase, Ms. Mendez. So, going in that spirit and see what comes out of the process. Yes.
It's just, to be quite frank, it's a bit strange because I do think that this position of this appellant before this court and also with the parties has been one in trying to get to some dialogue. Obviously, there's a lot of tension. There's multiple personalities here, and all of that is part of a complicated negotiating process. We have been trying to focus on the substance. We have been trying to always go back to the rights. But I will not belabor the point anymore. We are open to meeting with the appellants. I don't think it's even a choice, we need to meet with the appellants with the respondents, sorry. We need to meet with the respondents in order to actively participate and get this process going. So yes, and hopefully we can't be surprised, although the surprises we've had lately have not been so positive.
Yes, but that's why I use the word recalibration. Maybe.
Chair,
So,
I think the government wishes to intervene.
Sure.
Yes, I just wanted to say that the roadmap is really the heart of the thing, because, as I said, my instructions are to drive the roadmap to conclusion. But it seems like we're hung up on how to achieve these objectives and not focusing on the objectives themselves. And I understand the importance of all of that, but I want to reiterate the importance of us setting those milestones and then both of us working towards achieving them. And I think that's the approach that will bring these proceedings eventually to an end, rather than focusing on minute, the little things and all the little problems and not the big goals. I'm not saying those problems aren't real, they are real, but we'll have to step over some of them if we're to achieve anything.
Yes, well, I think we totally agree with that. So it would be wise and advisable, if not a requirement, that you meet. Now, even apart from representation, as I said, the two groups that are here presented are the appellants. So from that perspective alone, they are essential groups to talk to. So apart from other groups that may exist, etc., we also recognize that the government, of course, is free to talk to all other Maya groups that there are, but these are in the heart of these proceedings. So that must be absolutely clear, cannot be ignored. Now there was, so we talk about the roadmap, which is very important. There is also the Maya Customary Land Tenure Policy. And as far as this was sent to the appellants, but at that point in time, there was no response received. Has that response, that's still to be offered, Ms. Mendes? Okay, so that is...
Yes, that's pending with us, Your Honors.
Yeah, so that's another issue. And then the delimitation, briefly, auto delimitation, that is an ongoing project, but I don't know if you wish to talk about that now, because maybe we can leave that for another opportunity, but because we need to get things in the other fields also, but this is going on, auto delimitation, is it not? Ms. Mendes?
Yes, auto delimitation is ongoing, Your Honors. I think that there are some concerns that we have, but I think that we will address those in the context of the conversation that we have on the roadmap because they overlap.
Okay. Okay, now, so the idea is that at least there is a fundamental discussion, a meeting where these things can be discussed and see if some form of agreement can be reached. If not on all points, at least on a few. As this, as I've said, is an ongoing process. So would you are ready to meet at any time, Ms. Mendes?
Since yesterday, Your Honors.
Okay, well, Mr. Marshall, what could be a reasonable timeline?
Your Honor, I can speak for myself, but I can't speak for the rest of the team. I expect that it'll be the entire team that will be meeting. But we can undertake to schedule something within the next week with Ms. Mendes directly.
So, so let's say
today's Wednesday. Today's Thursday. I think I can speak to Ms. Mendes and try to work out a date by tomorrow, by close of business tomorrow.
Okay, so we could expect a meeting maybe in 2-3 weeks.
We're thinking within 2 weeks' time, yes.
Yeah, within 2 weeks.
Yeah.
Okay, and we don't have to get together for that, but it might be that if there are some results to report, that you could both parties succinctly report on any results, or maybe there are ongoing discussions, that is also possible, but that we will be kept abreast of what is going on. We will not have a specific compliance session for that unless something urgent pops up, but we want to keep abreast of the developments. I'm not sure if we should have a date for a new compliance meeting hearing now. We could wait and see how things go, and then decide. Then we will notify you of some other date where we want to hear the parties again.
What could be interesting as well, Chair, is if we got hopefully an agreed roadmap.
Yes.
So then that would indicate the landmark where a compliance hearing would be useful. So
yes,
you know, let's see how that works.
Yes. I think it's clear to everybody what is needed. And we also know there are many interests on all sides. So that makes it a complicated process. But in the end, we have to get to a point that is satisfactory. These things are not easy to achieve. So you will have a meeting within 2 weeks. I suppose the government can notify the other party when they are available for the meeting, and then not on a very short notice, but you know that you can discuss a date where you have a proper discussion about the subjects that are here before us. And then we will hear from you when there is some results to be reported.
If it was possible, Chair, it would be wonderful if there could be a combined report coming out of that meeting. It may not be possible, of course,
no,
but it would be wonderful if both sides could issue a joint communique as to the fruits of the meeting. Of course, if people can't agree, then we understand the separate reports. But again, just to build the trust and the confidence, if we could just get to that point, you know, I think that would be very helpful. But
yes, well, you never know. Miracles do happen, and it should not really be a miracle. But anyway, we'll see how things
there are
go.
lots of people who believe in miracles, Chair.
I am aware of that. Yes, and sometimes they're right too.
Indeed.
But yeah, we have to get through this difficult period, and we have to get forward. We have to go forward. Good. Is there anything, Ms. Mendes, you want to say at this point, or can we conclude here?
No, Your Honors, obliged.
Okay. Mr. Marshallek? Any closing?
Your Honor, no, we will make every effort to try to agree a way forward. I think that's the best approach.
Okay. Good. Okay, well then, I hope things go well. We'll hear from you if there is something to report. We hope good news, but you never know. Anyway, the news has to be good at some point because we need to get a result, a proper result. So thank you very much for your attendance today. Madam Deputy Registrar, can we close off?
Yes, we can. Thank you, Mr. Justice Witt. Thank you, Mr. Justice Anderson. Thank you, Madam Justice Rajnath Lee. Thank you, Council and Professors. And thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.